Good morning, everyone. It's great to have a good turnout here for the Commissioner Track. And as you know, this is a two-part Commissioner Track today, morning and afternoon. I'm Jean Kelleher, a member of the board of IAOHRA, and I'm director of the Alexandria, Virginia Office of Human Rights. It's a treat to be here with all of you, old friends, and meet new friends. And it's my distinct pleasure to introduce Erika Pierson, who is the Chief Administrative Law Judge in the District of Columbia. She's had this experience as Chief Judge since 2019. Her bio is in your book, so I'm going to let you read all the details. But she is a true leader on behalf of pro se litigants and on behalf of all of us and all of you who do this important work. So let me introduce Erika Pierson, and I'll see if we can get a few more chairs, okay?
Good morning, everyone, and welcome to Bethesda, to the District of Columbia. On behalf of DC Mayor Marion Bowser, it is my pleasure to be here today. My name is Erika Pierson. As she said, I am the Chief Judge for the DC Commission on Human Rights, as well as the DC Office of Human Rights. I've been the Chief Judge for 4 years. Prior to becoming to the Commission, I spent 13 years as an administrative law judge at the DC Office of Administrative Hearings, which is a central panel general jurisdiction court. So I have a lot of experience adjudicating cases and dealing with pro se litigants. And so I'm going to share some of that knowledge with you. Just quickly at the agenda, what we're going to go over in the morning session. I'm going to give you some overview of our commission and how we handle cases and how we're structured. We're going to talk about what it means to have a public hearing. We're going to go through the hearing process, the types of evidence that gets presented at administrative hearings. We're going to spend some time talking about hearsay and how that plays into administrative hearings. And then in session 2, we're going to talk about documentary evidence, taking official notice, managing the hearing, exhibits, burden of proof, surviving appeal, decision writing. And I'm going to ask you to, if you could, we're going to be a little interactive. I'm going to ask you some questions as we go along that will kind of help shape the conversation. And if you could either scan this barcode or you can go to the website. I promise you, you are not going to get any emails. You're not going to get any text messages, nothing like that. Once the session is over, you'll never hear from Poll Everything or anything like that. So you don't have to worry about that.
Judge, will your slide deck be available
Yes.
to us after this?
It'll be posted on the website afterwards. All right, so we're just going to do just a little sample question to make sure it's working. So the sample is, what is your favorite season? And so you should see that question on your phone. And if you don't have the Wi-Fi, the password is IAOHRA23. Yes? So you should see that first question once you log in. You don't have to put your name. It asks you when you log in what your name is. You can skip that if you want. All the questions are anonymous, so your name is not going to post.
Can I ask you a question? So the
Yep.
first poll question shows up for me when I did the QR code is what makes testimony credible?
Really?
Okay.
Is that what you're seeing as well? It's not going in order for some reason. Okay. Or try maybe, no, that one doesn't have it. All right, let's maybe, are you seeing this question? You're still seeing the same question? Okay, so I'm going to skip these because I don't know what's going on with it, why it's not behaving. We'll move on. A little bit about the DC Commission on Human Rights. It's established in 1970 by statute. It is part of the Office of Human Rights, which is the larger office and agency, but we are independent of the Office of Human Rights. Excuse me. It is composed of 15 commissioners. Our commissioners are appointed by the mayor. They serve 3-year staggering terms, and they serve without compensation. So all of our commissioners are volunteers. They all have various backgrounds in human rights. The mayor designates the chairperson of the commission. The chairperson plays a very big role in moving our cases along. They make the final decision only in private sector cases. They are not involved in the public sector cases. Under our statute, they can also serve as hearing examiners, and I think that's pretty common with most jurisdictions, but our model is that they don't serve as hearing examiners. Only the administrative law judges serve as hearing examiners, and then the commissioners serve as more like a jury in our cases in making the final decision after the administrative law judges have adjudicated it. So the Office of Human Rights, which is our overarching agency, they're charged with investigating the complaints, issuing a probable cause determination. There's a mandatory mediation that happens at that stage, usually twice. It happens when the case is filed, and then it also happens after the probable cause finding, so that by the time the cases come to us, the parties have been through 2 mediation sessions that have been unsuccessful by the time it comes for a hearing. They also have a responsibility to educate the public on human rights. So they do issue a lot of fact sheets and guidance for employers. They do a lot of community outreach and training in the public. And so we have a bifurcated process, and this may be a little different than how other jurisdictions handle their cases. So our process is all of the cases, once probable cause is found and it's certified for a hearing, they are certified to what we call the hearing unit. And the hearing unit is composed of administrative law judges. And we do all of the pre-hearing process, the hearing itself, and we issue a proposed decision. And then if it is a private sector case, those cases all ultimately go to the Commission on Human Rights. If it's a public sector case, which means DC government is a party, it's a DC government agency that the complaint has been brought against, then that ultimate decision goes back to the director of the Office of Human Rights. But the hearing process is the same, whether it's a private sector or a public sector, but who makes the final decision is different, and the appeal rights are different. So if it's a private sector case, it's considered a contested case under the Administrative Procedures Act, and so it's appealable to the DC Court of Appeals. But if it is a DC government case, it is considered a final agency action and not a contested case under the Administrative Procedures Act. And therefore, it's appealable to DC Superior Court, and then DC Superior Court decision can be appealed to the DC Court of Appeals. So that is the difference between private sector and public sector, but the Commission handles only private sector cases. And so our jurisdiction, what it says, if the parties fail to execute a conciliation agreement, the office shall certify the case to a commission for a public hearing. It also says that if our parties fail to execute a conciliation agreement, the office, I already said that, I'm sorry. After a probable cause finding, the respondent shall answer the charges of a complaint at a public hearing before one or more commissioners or before a hearing examiner. So we're going to talk about what it means to have a public hearing. And when we talk about a public hearing, all that means is it's a trial-like proceeding. There's nothing else special attached to the term public hearing except that it is open to the public. And it also means that it's governed by the Administrative Procedures Act. You have a question?
It's also a de novo hearing, too?
It is a de novo hearing, correct. And we're going to talk more about that. Absolutely. So almost every state, county, jurisdiction has some form of an Administrative Procedures Act. In the District of Columbia, our Administrative Procedures Act is modeled after the federal Administrative Procedures Act. It's almost identical with very small differences, and that's true pretty much across the board. And so we always want to keep the requirements of the Administrative Procedures Act in mind when we're processing these cases. And so the roles in our litigation, and the roles can be different based on how your commission or board is structured, but in our cases, again, the Office of Human Rights conducts the investigation, issues a probable cause finding. The Office of Human Rights represents the complaint in our cases, not the complainant. They don't represent the party. They represent the public interest. they are not a party in the government cases, and that is because we can't have government versus government. So when you have a government case, they are usually represented by the Office of the Attorney General, and we can't have the Office of Human Rights going against the Office of the Attorney General. So they play no role in litigation when it comes to public sector cases. But in private sector cases, they represent the public interest, and they are a party. So we have three parties in our cases. We have the complainant, we have the Office of Human Rights, and we have the respondent. Now, another model that a lot of jurisdictions follow is that the agency acts more like a prosecutor, and the complainant doesn't participate in the proceeding. But in our cases, the complainant does participate. They are a party. They have to actively conduct discovery. They have to carry their burden of proof, but they do have the assistance of the Office of Human Rights in being able to understand the process and move through it. So the Office of Human Rights will work with the complainant as part of the hearing, but they don't represent them. The administrative law judge conducts the hearing on all pretrial matters, issues a proposed decision, and then we have a tribunal of 3 commissioners that make the final decision. And our commissioners, we rotate it and assign which 3 commissioners are going to sit on the tribunal, and then the final decision is appealable to the DC Court of Appeals. So is anybody seeing this question? If not, I'll just do it just by a show of hands. How many people here are administrative law judges? Any? How many are commissioners? Okay, so a lot of commissioners, board members, hearing examiners, and attorneys or other, okay. Case manager, excellent. So in our cases, 75% of our respondents are represented by counsel. Only 35% of our complainants are represented by counsel. And we do not have any kind of attorney referral program. We did at one point, but due to some litigation that occurred where there were some challenges to what it meant to represent the complaint, and that issue going to the DC Court of Appeals in order to kind of make a clear break, the agency stopped referring cases to attorneys and paying for those attorneys. So complainants are now on their own completely to be represented by counsel. We do have a lot of local legal providers that will provide free legal services because, of course, these are fee-shifting cases. If you're a prevailing party, you can get attorney's fees. So places like Neighborhood Legal Services, ARP, they often come in and represent the complainants in our cases for free. But still, only 35% are represented by counsel. So we have a lot of pro se litigants. And so one thing about pro se litigants is what the DC Court of Appeals has generally said is that pro se litigants are not entitled to special treatment or substantial assistance from the judge. However, there are exceptions in circumstances that require special care by the judge. And those circumstances are that you really should not hold a pro se litigant to the same standard you're going to hold an attorney to when it comes to filing deadlines, process, formats of filings. In those kind of situations, the courts have said you need to be more flexible. And you need to provide some assistance, and you need to let them know what their procedural rights are. You can't assume that they're reading the rules and that they understand that if they don't file a response to this motion, I'm going to treat that motion as conceded. And the court is not going to affirm that if you have not explained that to a pro se litigant. You let them know what their rights are and what's at risk if they don't comply with your order. And we've had cases that have been remanded simply because the administrative law judge didn't clearly explain to the pro se litigant what's going to happen if you don't do X, Y, Z. Mm-hmm.
So what's the difference between sharing that information but not providing legal advice to the pro se litigant?
Well, it's not so much legal advice when you're talking about procedural issues. It's legal advice if you say, this is what you need to do. You need to call this witness and they need to say this in order for you to meet this burden. But when you're talking about following the procedural rules, that's not legal advice. That's more technical advice. And so the court isn't going to look poorly or consider you giving legal advice when you're helping with the technical assistance. And so the courts have said that pro se litigants are allowed more latitude than litigants represented by counsel to correct defects in service of process and pleadings. So when they don't file something correctly, The courts are very critical when you just reject it and say, too bad, you didn't do this right, and now you've lost. You've lost your opportunity to file this response. You've lost this opportunity to file this motion. You need to give them another chance to fix it. You may not have to give that to an attorney because we hold attorneys to a certain standard, but we're not going to hold a pro se litigant to the same standard that we're holding attorneys to. And so it's important to provide pro se litigants with the necessary knowledge to participate effectively in the process. And this quote here is from a remand that we had a couple of years ago from the DC Court of Appeals. And this was a case where the complainant had requested a continuance of the hearing. I gave a fairly good reason for the continuance, and that continuance was denied. The complainant didn't show up on the scheduled hearing date. The administrative law judge dismissed the complaint. He appealed that to the DC Court of Appeals. The DC Court of Appeals remanded it back to the administrative law judge, and they said the commission should heed the court's admonition that because many litigants seeking relief from the commission are pro se, the regulation must be interpreted with them in mind, with the goal of ensuring that the system is accessible to individuals who have no detailed knowledge of the relevant statutory mechanism and agency processes. So I'm going to move on to kind of the laws that we enforce. We only enforce District of Columbia law, but we do rely on federal case law. And we are also have a FEPA organization, so we do have a partnership with the EEOC, with HUD, and the Department of Justice. So we do also enforce Title VII of the Civil Rights Act when those cases are cross-filed with the EEOC. And so the EEOC, they allow us to hold a hearing. They will be bound by the decision that we make in that case. It's really important that you are cognizant, though, even though most of human rights acts are very similar to Title VII, they're not identical. And so it's really important that you are aware of what are the differences between your local laws that you're enforcing and Title VII and other federal laws when you're applying them. And this is especially true when it comes to issues like causation. So for example, the DC Human Rights Act is much more liberal than Title VII when it comes to causation. And the only standard is motivating factor. Whereas when you're dealing with Title VII, you have motivating factor in some areas, and you have a but-for causation in other areas. So that's a big difference between a local law and federal law when you're applying that federal case law. So really important that you're cognizant of the differences between the laws. And also you have to keep in mind that when you're looking at cases that are interpreting Title VII of the Civil Rights Act, Title VII only applies in employment. And it only has these particular protected traits. It only covers race, color, sex, national origin, and religion. And it only applies to 15 or more employees. And so in the District of Columbia, our Human Rights Act applies to all employees. You only have to have one employee for it to apply. And we have 23 protected traits, not just 5 protected traits. Now, there are other protected traits, but they're under other acts. So, for example, disability is under the Americans with Disabilities Act. In DC, disability falls under the DC Human Rights Act.
Yes.
Yeah.
What's the difference between race and color?
Color is really based just on your skin, what you look like. But race is where you're associated with, what is your actual nationality. And there's a lot of crossover between color, race, national origin, and in those type of cases, most people will file complaints that will include all 3 of those protected traits. So I'm going to talk a little bit about the DC Human Rights Act of 1977. Like I said, we have 23 protected traits. It is the most number of protected traits in the United States. It is the most progressive human rights act in the United States. DC is very, very liberal jurisdiction. They're very much on top of keeping current in the law. I know this morning the person from the EEOC was talking about the Pregnant Workers Fairness Act that was just passed. DC passed that in 2014. We've been enforcing the Pregnant Workers Act for 10 years in the District of Columbia, and it's just now being passed in the federal government. So that's very typical in DC. And then some of our protected traits that that are a little unique to, you don't necessarily see everywhere, are like gender identity and expression, marital status, family responsibilities, place of residence. That's a big one here because DC, Maryland, Virginia, it's very incestuous. Everybody, lives in one, works in the other, crosses back and forth. Sometimes there's residency requirements imposed in DC jobs and things like that. So we do have a lot of issues surrounding place of residence, and it's a protected trait in the District of Columbia. Matriculation, credit, political affiliation. And our two newest traits just passed in 2023. Homeless status this year became a protected trait, and eviction records became a protected trait in the District of Columbia. Areas of enforcement: housing, public accommodations, employment, and education. Now, the majority of our cases do come in the employment context. Our second highest number comes in housing, particularly dealing with a source of income. We have a lot of cases dealing with refusing to accept perhaps a housing voucher, things like that, in the District of Columbia, and then public accommodations, and then education are as far as frequency of cases.
What kind of cases are you saying in education?
In education, they have primarily been not allowing a student with a disability to participate in perhaps an after-school activity or something like that. Most of them have involved students with disabilities.
So
Yes.
in the previous slide, you had family responsibilities.
Mhm.
How does that differ from HMLA?
From FMLA? Family responsibility is just based on if you have to take care of a child, you have to take care of a parent-in-law, then that's a protected trait. So it's actually more expansive than FMLA. And FMLA is just going to protect your job for a certain period of time. So it's not dealing with it as a protected trait. But somebody would say, I'm not going to give you a reasonable accommodation because you have to take care of your father-in-law. Then that's a family responsibility. That's a protected trait. Mm-hmm.
Just curious about the kind of cases you're seeing coming in from the DOJ. Specifically, do you see cases relating to employment discrimination based on citizenship versus national origin?
Not so much citizenship, but we have lots of national origin cases, yes. Yes. So the next question that isn't about was a question of how many cases, what percentage of cases do you think prevail in district court that are Title VII cases? Just call out any number that you think. How many complainants win in the district court?
5%.
5%?
75?
All right, it's 1%. 1% of complainants prevail in the district court. And so it's just a little data looking at the DC, looking at the EEOC, and looking at district court. The data is pretty consistent between DC and the EEOC as far as the types of cases we see. In DC, 26% of our cases are sex and gender, 30% are federal. 25% of our cases are race, 30% of the federal cases are race. 10% of our, 18% are disability. Now, you don't see disability under EEOC because it's not Title VII. So it's prevalent in federal, but disability is an ADA case. It's not a Title VII case. But for us, it comes in fourth for the large number of cases that we get. Then 10% are age, and that is consistent with the third most frequent case before the EEOC. 22% of their cases are age. 33% of our cases have a claim of retaliation. It's not a protected trait, but it's a claim that you can bring. And 50% of the EEOC cases include a claim of retaliation. And when you look at what's going on in the district court, 13% of the cases are dismissed based on granting summary judgment to the employer. That's a really, really large number of cases that are dismissed at the summary judgment stage, because summary judgment is, the courts say we use it scarcely. So that's a really, really high number. And again, only 1% of complainants prevail in the district court. And last year, there were 192 damage awards out of 72,000 cases that were filed in the district courts. So the chances of winning are not high, and that's true in before our court as well. We have a very low success rate when it comes to the complainants' cases.
I have a question.
Mm-hmm.
So are some of them on
cases actually settled?
Yes, absolutely, yeah. We settle, 80% of our cases settle. So even though the parties have been through 2 mediation sessions, by the time the case comes to us, we do mediate it one more time. And it's optional once the case comes to us. It's not mandatory mediation, but we do offer it. All of our administrative law judges are certified mediators. And we usually do it after they've conducted discovery. So once the parties have gone through discovery, they have a much better understanding of what the strengths and weaknesses are of their case. So it's very different than when you're before the agency for a probable cause finding, because you don't know what the other side's evidence is. But now you know what the other side's evidence is, and so they're a lot more open to mediation after they've gone through the discovery period. And so we do have a very high mediation and successful rate before the commission.
Is the success rate so low because there is a lack of evidence?
It's low because, and we'll talk more about that this afternoon, it's low because of the McDonnell-Douglas burden shifting framework. Because of the requirement that the employee has to prove that pretext is not the real reason for the adverse employment action. In most cases on summary judgment, they fail at the pretext stage. It's very, very difficult for a complainant to prove pretext. And so these are just some numbers from the Office of Human Rights. They received, this is from 2019, 1,598 complaints a year. Oh, question?
I was wondering about the effects of status of limitation
Oh, statute of limitation?
on violence in the District of Columbia.
The timelines?
Yes.
So in the DC, the statute of limitations is 3 years. But on sex cases, if it's sexual harassment, it's 1 year. But we actually have a bill pending right now to change that to 3 years for sexual harassment as well. All right. So of the 1,598 complaints that are filed, they docket about 450 complaints each year. The other ones are dismissed and not followed through all the way through investigation. So 450 get docketed. 52% of the cases are settled before the Office of Human Rights, and they, on average, have $2.5 million a year worth of settlements. And so this is just, again, a little data on how federal employee discrimination cases are resolved. You see only 1%. Employers win 14%. 7% are resolved by procedural issues. For example, summary judgment would be procedural, motion to dismiss. And then 78% also settle before the district court. And so we don't really know what those settlements are. So our hearing process, and we do offer mediation, and that is optional. We have an initial hearing as soon as the case comes to us. We usually hold that initial hearing within 30 days of the case being certified to us, and that initial hearing is going to open that discovery period. We allow 60 days for discovery. Well, half of the cases will actually get through discovery in 60 days. A lot of times there'll be lots of continuances and motions to expand discovery, and it really can take up to like 6 months to complete discovery, but we really try to discourage the discovery period from stretching out so long. Also, one of the things that we're looking at right now is we're getting ready to pilot sort of what we would call form discovery. So instead of having the parties going into private discovery, we will have a preset discovery questions that each party must answer depending on the type of case and have them exchange that information within 30 days. So we're getting ready to start a pilot on that and see how that works in moving these cases a little faster. After the discovery period, we usually set a schedule for dispositive motions. That's motions for summary judgment, motions to dismiss, or any other kind of technical motions that would get rid of the case. You have a question?
Just wondering how the timeline for dispositive motions work, like how long before the hearing the parties usually have to get those in?
We usually have 30 days after discovery ends, you must file your dispositive motion. After dispositive motions, assuming the case is not dismissed on a dispositive motion, then we go to joint pre-hearing statements. It's up to you as a hearing examiner whether you want to require joint statements or individual statements. We require joint statements because we want the parties to talk. We want them to come to as many agreements as possible. And if they're not required to do a joint statement, then they're just going to throw everything and anything into those pre-hearing statements that is not going to be helpful in coming to any resolutions for the case. So they have to submit one joint pre-hearing statement that they must meet and compose together. Now, there are some circumstances where we will allow them to do separate statements, and that is if we have a really, really difficult complainant. Or, for example, a complainant with mental illness that we just know they're unable to function in that setting. We'll say, just go ahead and do separate pre-hearing statements. And after the pre-hearing statements are filed, about 30 days later, we'll hold the pre-hearing conference. And then after that, we'll go to the evidentiary hearing. So for us, the average life of a case from the time it gets certified to the time it is resolved is 15 months. So the pre-hearing conference is really, really important. You really want to address as many of your procedural issues at your pre-hearing conference as possible. You don't want to spend a whole bunch of time at trial dealing with objections that could have been dealt with before the hearing. So you want to make sure you're clear on the issues for the hearing, because a lot of times when the case goes to investigation, they have a probable cause decision, they might have had 5 allegations, and the agency found probable cause on 1, and no probable cause on 4, but a lot of times your complainant is still arguing all 5 of those allegations. So you want to make sure at the pre-hearing conference that you're very clear with the parties. This is the only issue we're going to resolve at this trial. We're not going to talk about anything else except for this issue. You want to make sure you've talked about the relief sought, because a lot of times it's never been discussed. The complainant, there's nothing that has required up until now the complainant to say, what do you want out of this case? What are you looking for? I'm looking for a reinstatement. I'm looking for $5 million. They haven't been required to put that information forward yet. So they have to put that in the pre-hearing statement. And under our rules, if they don't put it in the pre-hearing statement, they lose the ability to request the relief. So they are limited in relief to what they've requested in the pre-hearing statement. You want to get them to stipulate to as many facts as possible. And it can be even the simplest facts. It doesn't have to be complicated, because do you need to spend time at trial proving that a complainant worked someplace from this date to that date? I think we can stipulate to that. We don't have to have testimony and evidence telling me how long they were employed, telling me what position they were in. So you can get them to stipulate to all of those basic facts. That can cut hours out of your hearing. Now, they may not stipulate to more complicated facts, but at least get the basic facts stipulated to, so that you don't have to deal with that at an evidentiary hearing. They have to identify their witnesses. Now, that doesn't mean, for us, we always have an issue where they call a witness at the last minute that wasn't on their witness list. That's always a touchy issue. You're always going to get an objection. Well, it wasn't on their witness list. They can't call the witness. But it really comes down to fundamental fairness, and we're going to talk a lot more about what fundamental fairness means. Is this witness going to be a surprise to the other party if they testify? That's really the most important question that you're going to ask if they didn't put that person on their witness list. And you want to deal with any objections to witnesses or exhibits, particularly experts. You don't need to wait till your trial to figure out whether you're going to accept somebody as an expert. That should be done at the pre-hearing conference. If they have an objection to calling someone, lay that out at the pre-hearing conference and make the decision at the pre-hearing conference whether or not you're going to allow that expert to testify. There's no need for that to spend an hour of your trial on certifying whether you're going to allow an expert to testify. And so this is just an example of what we use for pre-hearing statements. We provide the parties with a fillable form. So they know exactly what information we're looking for. So it tells you respondents' claims and defenses, stipulated facts, what are the facts that are in dispute that we need to talk about. Then there's OHR, so it's for each party. And so that works really well. But you can also see there's lots of samples. So this is one from New York courts that they use as a pretrial statement. And it's not a fillable form, but really asks for the same information that we ask. So there's lots of samples out there if you need to come up with something to provide to the parties. I wouldn't let them just, do it completely on their own. You need to be very clear what information you're looking for in a pre-hearing statement. We also require that they, as part of their pre-hearing statement, they submit their exhibit list. So this is the exhibit list that we use. This is a common one. This actually comes from the National Association of Administrative Law Judges with a few tweaks. And so I require that they submit their exhibit lists in electronic form. So I'm able to edit that list during the hearing. I'm using this list during the hearing. And so I keep a column for objections, only to the extent that, sometimes you're going to, in your final decision, you're going to have to explain why you overruled an objection or you sustained an objection. So it's just a reminder that there was a serious objection to this exhibit. You allowed it in over the objection or you didn't allow it in. And so that's why we keep that objection column in our exhibit list. And just some best practices for managing exhibits. We want to make sure that the exhibits are labeled. We require the parties to label their exhibits themselves. Now, if you're a pro se litigant and you can't do it, it's complicated, we will do it for you. We do have law clerks. And so we will let them know, as a pro se litigant, if you're unable to understand how to label your exhibits, they just have to give it to us in time. And our law clerk will place the stickers on the exhibits and label it for them. I suggest you assign identifying numbers, because if you don't assign numbers, you're going to have both parties filing exhibits with the same number. Both parties are going to label them 1, 2, 3, 4, 5, 6, or A, B, C, D, and it gets confusing, especially when you're dealing with a lot of documents. So we assign numbers based on the party. If you're the complainant, your exhibits begin with the number 100. If you are a respondent, your exhibits begin with the number 200. And if you're the agency, your exhibits begin with the number 300. It just makes it easier to keep the exhibits separate and know whose exhibit it belongs to. We do ask that they Bates number the exhibit, and I ask that they submit all of their exhibits in a single PDF file, as well as a binder that is delivered prior to trial. So let's start talking about some evidence issues. The types of evidence that you're going to deal with are real evidence. Real evidence is tangible evidence, things that you can touch. Documentary evidence, testimony. We're going to talk about judicial notice versus official notice. There's recorded evidence, and there are stipulations. So again, the Administrative Procedures Act always needs to be in your mind when you're talking about how we're dealing with evidence. And the big thing in the Administrative Procedures Act is that the rules of evidence don't apply. Now, that is not true everywhere, so you need to know what your law is. That is true in most jurisdictions, but I know I did a training in South Dakota. South Dakota law says the rules of evidence do apply in their administrative hearings. So it's unusual, but there are some jurisdictions that require it. Most don't. And so that's the big difference between a traditional trial and an administrative hearing, is that the rules of evidence do not apply. So why don't the rules of evidence apply? And it's important to know why they don't apply, because the parties are going to argue with you. They're going to still object on hearsay grounds. They'll still object that this rule of evidence requires this rule of evidence requires that. And sometimes you have to explain to them why the rules of evidence don't apply and why they need to trust you. And the reason they don't apply is they were really developed for juries. We have to be very careful with a jury what information is going into their ears, because we only want them to have the relevant information. And they can be skewed if information that's impermissible is stated in the courtroom. So you don't have that issue in an administrative hearing because it is a bench trial. It is just the judge at the case. And the judge knows how to weed out relevant information versus irrelevant, inadmissible versus inadmissible. And the parties need to trust that you're going to do that. It's also been argued that to require an administrative law judge to reject inadmissible evidence makes no sense because there's no jury to protect, and the agency official is equally exposed to the evidence, whether they admit it or they exclude it. So that's also what's different in administrative hearing. You've been involved in this case from day one. You've read the documents. You've seen the pleadings. You've seen the discovery. You already know all of the stuff that they're going to present. So it doesn't matter. You know it. You just have to weed it out. And you know that when you're making the decision, what's the relevant evidence that you need to consider in making the decision. And administrative agencies' further policy goals that the legislator has decided can best be promoted through a more efficient and speedy process than available in traditional judicial arena. So you don't need to waste time arguing about whether or not something is going to come in. And so I'll skip that. And so a lot of times what you'll hear or you'll read in appellate cases is that you have relaxed rules of evidence that apply in administrative hearings. So what does it mean to have relaxed rules? It means that since the applicable test in an administrative hearing is not whether the evidence is admissible, under the strict rules, the standard is whether the evidence possesses probative value, commonly accepted by reasonable and prudent persons in the conduct of the affairs. That's what we mean by relaxed rules of evidence. It's not without limits. The courts have said the rules can't be so relaxed as to disregard due process and fundamental rights. So you need to always ask yourself when there's an objection, is it fair? Am I going to be unfair to the other party if I allow this testimony in or if I allow this document in? It always comes down to fundamental fairness. It does not come down to the rules of evidence. And the U.S. Supreme Court has held that the matter comes down to the question of the procedure's integrity and fundamental fairness. And if you have not ever read the Richardson versus Perales case, I recommend everybody read that case because it's very important, laying the foundation for why we don't apply the strict rules of evidence in administrative law. It's Richardson versus, here, I'll go back to it. It's right in the bottom here. Richardson versus Perales, 402 U.S. 389. And so when we say fundamental fairness, the Supreme Court has also held, I think that's the same with the other one. Sorry, I gave you the same quote. But it doesn't mean that you can't apply the rules of evidence. You know, sometimes applying a rule of evidence helps with the orderly presentation. So it doesn't prohibit it, it just doesn't require it. And under the Administrative Procedures Act, and this is from both the federal and our DC Act are identical, and what it says is that any oral or documentary evidence that is not irrelevant, immaterial, unduly repetitious is admissible. And I emphasize that it says any evidence is admissible. That's not true in a traditional trial because we're applying the rules of evidence there, not any evidence. This is the only place you're going to see where it says any evidence is admissible, and you always need to keep that in mind. And evidence is relevant if it tends to prove or disprove a material issue that's raised in the charge or the complaint. And then the Administrative Procedures Act also talks about your findings of fact and says that to satisfy the requirements of the APA, the findings of fact must be based on reliable, probative, and substantial evidence. That is the APA standard across the board. And so when we're talking about reliable evidence, it means that it's dependable or it's trustworthy. And what the Court of Appeals has said is that the factors you want to consider in whether or not evidence is reliable is whether the witness is qualified to testify. Do they have a basis for what they're talking about? Then if they have a basis for what they're talking about, they're qualified to testify. Are they making factual statements rather than conclusory statements? They need to testify to facts. And are they disinterested in the outcome? So, of course, anytime you have a witness who is interested in the outcome, it doesn't mean that they're not reliable or they're not credible. It just means that you need to really question whether they're reliable or credible. So for example, you often have spouses testifying, especially when it comes to damages. You often have spouses testifying to how something has physically manifested in the spouse because of this adverse action. Well, you know, spouse, they definitely have an interest in the outcome of the case. Now, it doesn't mean that they're not reliable, but you're going to have to explain why they're reliable. Why did you find that that person is reliable, and why did you believe their testimony or not believe their testimony? And then substantial evidence. Under the Administrative Procedures Act, courts of appeals will review your factual findings under the substantial evidence standard. And this is an extremely deferential standard. So you don't always get the standard, for example, coming from the Office of Administrative Hearings, which was a general jurisdiction court. Their decisions were not given the same level of deference that the commission's decisions are. And that's because the commission is considered an agency with expertise. Whereas the Office of Administrative Hearings, being general jurisdiction, they're not considered to have expertise in any particular area. So the court gives much, much less deference to that agency decision. But when you are a commission that is charged with deciding a certain type of case, and in addition to being charged with deciding cases, you're also charged with rulemaking, that puts you at a really, really high level of deference before the court, because that says to the court that the council or Congress or whoever has passed your enabling act has put great faith in this commission because they've given you the power to decide cases and they've given you the power to issue rules. That's a lot of power. So we consider you an agency with expertise, and we're going to give a high level of deference to your decisions. And so when you give that kind of deference, a reviewing court is going to uphold the agency's findings unless the evidence presented will compel a reasonable fact finder to reach a contrary result. And so substantial evidence, under the law, it's defined as more than a mere scintilla, and nobody knows what that means. Like, what that's the worst definition ever, a mere scintilla. But it's defined as such evidence as a reasonable mind might accept as adequate to support a conclusion. It's supported by less than a preponderance, but more than a scintilla. So if you look at the levels of proof, a scintilla is very low. It's just above no evidence at all. Scintilla is just tiny bit of evidence. And then you have preponderance, which is our primary burden of proof, and substantial comes just right beneath preponderance, and of course, the highest standard is beyond a reasonable doubt. And we never have a beyond a reasonable doubt standard in administrative hearings. Administrative hearings are always going to be either preponderance of the evidence, or there are circumstances where it could be clear and convincing evidence. But most of the time, it's going to be preponderance of the evidence. So we talk some about hearsay. Hearsay is, probably the thing that is argued the most in administrative hearings, at least in our administrative hearings. Now, the attorneys know. They know hearsay is admissible in administrative hearings, but they're still going to object on hearsay grounds, and that's okay, because they want to make the record, because they still can appeal, and they can still make an argument that it was unreliable hearsay and shouldn't have been relied on. So you want to let them go ahead and make that record, even though they know that it's admissible. And so what is hearsay? Another very unhelpful definition, it's an out-of-court statement offered for the truth of the matter asserted. That's the legal definition. But really, it just means that it's evidence that's based not on personal knowledge, but on something somebody else told you. So, and particularly if it goes to the ultimate issue, then it becomes more difficult to accept it as a fact. It's always admissible in administrative hearings, but the fact that it's admissible doesn't mean it's reliable. So you can take it, but it doesn't mean you have to believe it. It doesn't mean that you have to rely on it. You can reject it. That's your discretion, and you have to make that decision. So why is hearsay admissible? Again, because there's no jury to shield. You know, the rules on evidence were made to shield the juries from getting information that they shouldn't have that will affect their ability to make a decision. You're not in that same danger as a judge, and so we don't need to exclude evidence just based on the fact that it's hearsay. Also, not all fact finders are attorneys. We have plenty of commissioners, board members who are not attorneys. On our commission, we have about 50%, it's about half. Half of our commissioners are attorneys, half of our commissioners are not attorneys. And it's, well, no layperson wants to deal with the rules of evidence. It's very, very complicated. So that's taken into consideration in administrative hearings. And again, we use the substantial evidence standard when it comes to hearsay. And what the courts have said is that hearsay may constitute substantial evidence in administrative proceedings with the weight ranging from minimal to substantial. You can give it little weight, you can give it a lot of weight. It's up to you based on how you perceive that evidence. It's a case-by-case evaluation, and its weight is determined by the item's trustfulness, reasonableness, and credibility. And those are all within your purview. So it's a two-part inquiry when you're looking at substantial evidence when it comes to hearsay. Whether the agency adequately explained, I have a typo there, how it derived its conclusion, and whether the court believes the agency's conclusion is reasonable on the basis of the record. That's the analysis that you go through when you're trying to decide whether you're going to accept hearsay. I'll skip that. And so the Court of Appeals has said that the factors to consider in whether hearsay is reliable is whether the declarant is biased. Of course, that is going to make any kind of hearsay testimony suspicious if the person has a reason to be biased. Maybe they have an interest in the outcome. If it's not corroborated, it could be corroborated by another witness's testimony. It can be corroborated by documents, by photographs. Is there something else that supports this person's testimony that makes it more reliable? Because you're not the only person who said this. That makes it more reliable. Whether it's contradicted by direct testimony. You have to be very, very careful when you have hearsay testimony up against sworn live testimony. Whether the hearsay statements are signed or sworn, are you talking about a document? Is it a sworn declaration or an affidavit? That makes it more reliable. And then we have what's called the legal residual rule. And you need to know whether this applies in your jurisdiction. It does not apply in the District of Columbia. It's been rejected now by most courts, but not all courts. And what the legal residual rule says is that administrative hearing bodies should never ground findings of fact solely on uncorroborated hearsay, because uncorroborated hearsay is not substantial evidence. Now, that was the old rule, but it still applies in some jurisdictions. So you need to know, does your jurisdiction adopt the legal residual rule, or have they rejected the legal residual rule? So under this rule, when all the evidence is received, it's been sifted through by the reviewing court, there must be present at least a residuum or residue of legally competent evidence that supports the agency's findings. So that just means that if all you have in the case is hearsay, and you have no other evidence, no other testimony supported that hearsay, no documents, no photographs, nothing else backs it up, it's not enough. You can't rely on it and then lose the case. But again, very few jurisdictions still follow this rule, but there are still some jurisdictions. So can findings be based solely on hearsay? It depends on the rules in your court. Again, if the legal residual rule does not apply, then yes. Then yes, it can be based solely on hearsay. But it creates a problem. It creates a problem when all you have is hearsay, and you have to really flesh it out in your decision. And so courts subject administrative agency decisions based solely on hearsay to what they call exacting scrutiny. If that's all you have, the Court of Appeals is going to look really, really hard at whether that was substantial evidence if you're only relying on hearsay. And so, and just here's some examples of how different jurisdictions have handled it. Can findings be based solely on hearsay? Maryland. Maryland says yes. Maryland says if such evidence is credible and sufficiently probative, it may be the sole basis for the decision of the administrative body. The District of Columbia also says yes, although the Court of Appeals has adopted a flexible approach that rejects any rigid threshold requirement of competent corroborating evidence. Administrative findings and conclusions based exclusively on hearsay are subject to exacting scrutiny. So it's admissible, we'll take it, but we're gonna give a really, really hard look at it on appeal. But then we look at Wisconsin. Wisconsin says no. Wisconsin has adopted the legal residual rule. Wisconsin says requiring corroboration of hearsay by non-hearsay evidence ensures the evidence is properly tested, thereby ensuring the fundamental fairness of administrative hearings. So it really does vary from jurisdiction to jurisdiction, so make sure you know what your rules are in your jurisdiction. And some things to be careful about when you're applying hearsay: very careful crediting uncorroborated testimony up against live sworn testimony. You have a witness who's present, testifying from firsthand knowledge, they've been sworn in, the courts say, now they can lie, of course, and then you find they're more credible. But if they testify and you find them credible, then you have to credit their testimony over the hearsay testimony because you have found them credible. And where the declarant is available to testify and be cross-examined, the practice of relying exclusively on hearsay is strongly discouraged and should be heavily weighted against the sponsoring party. So is a party presenting hearsay testimony instead of a witness that they could have called, a witness that is local, a witness that is available, but they've chosen not to call that witness, but instead are putting on hearsay that's questionable? Why are you doing that? It makes it less reliable if they had the ability to call a firsthand witness and didn't do it. And so hearsay, again, also a two-step process, is consider the reliability and probative value of that hearsay testimony. And once it's deemed reliable and probative, consider whether the hearsay's admission contravenes due process. Is there anything patently unfair about allowing this hearsay evidence in? So for example, if it's the first time anybody has ever presented this information, you've been through discovery, this has never been presented before, I've never heard of this issue before, it's coming up for the very first time at trial, that could be a reason to say that it contravenes due process. Or maybe it's not fundamentally fair if it's never come up before and I'm not going to allow that hearsay testimony into this hearing. And so how do you handle hearsay objections? Because they're going to make the objections. They're going to make them all the time. It's very simple. They're going to say objection, hearsay, and say, well, I hear your objection, but hearsay is admissible in administrative hearings. The witness can testify, and the commission will give the testimony its proper weight. And then you invite them to make arguments about how much weight you should give it. Don't argue with me about whether or not I should accept the testimony. Tell me why I shouldn't give it substantial weight. Make that argument. So that's how I would respond when people make those hearsay objections. And so I think we are done for this first session. Hopefully I'll come back and join me this afternoon. Thank you so much.
Anyone have any questions? We have
Oh, sure, yeah. Absolutely.
What's the difference in the burden of proof from the OHR standard? Is that more likely than not as opposed to?
Yeah, for preponderance of the evidence? Yes. It's preponderance of the evidence is more likely than not, is the statement.
That's not what the burden of proof before the hearing examiner is, right?
That is the burden of proof before, yep, the hearing examiner. Yep. Do you have a question?
What is the maximum amount of financial damages that are awarded by commissioners?
And under our statute, we don't have a limit like they do in the federal statute. So there is a limit in federal court of how much can be awarded, but there's no limit here. And I think the largest award that I'm aware of is $3 million.
Ultimately, adjudicates dispositive motions in Pennsylvania, that goes to a panel of commissioners, and
Well, yeah, it depends. So if you are granting a motion for summary judgment or a motion to dismiss, that still goes to the commission because it's disposing of the case. But if you're denying it, it doesn't go to the commission. Just the ALJ can deny it and you move on to the next part of the process.
So in response to your QR code question, what makes testimony credible? Is it the reliability?
Reliable? Is it corroborated?
Okay,
Was there any bias on behalf of the witness?
okay.
Any other questions? All right, thank you, everyone.
Thank you so much.